The right to rectification. The scope of this right under GDPR is largely unchanged from the directive. In a nutshell, data subjects have the right to rectification of inaccurate personal data, and controllers must ensure inaccurate or incomplete data are erased, amended, or rectified. This right can generate a considerable amount of effort operationally. The Working Party 251 states the right to rectification might apply where, for example, an individual is placed into a category that says something about their ability to perform a task, and that profile is based on incorrect information. Rectifying wrong or incomplete entries in databases is usually not a singular, isolated issue for organizations. Data are often interlinked and processed that way, so any changes to any piece of data might have wider consequences. Further, the GDPR does not provide a definition of the term accuracy. However, some national privacy laws, such as the UK's Former Data Protection Act 2018, includes language that defines personal data as inaccurate if it is incorrect or misleading as to any matter of fact. It must be noted, though, opinions are by their very nature subjective. Consequently, it can be difficult to conclude the record in question is in fact inaccurate. As a best practice, it seems reasonable to ensure the record clearly shows that information's nature is considered to be that of an opinion. Where appropriate from the organisation's point of view, it seems further reasonable to honour the individual's explicit request even if the inaccuracy of the record cannot be completely proven. Under the GDPR, any individual can make a request for rectification either verbally or in writing, as there are no formal requirements attached to this. Instead, Recital 59 stresses the requirement to provide means for requests to be made by electronic means, specifically where personal data are processed by such means. Therefore, the organisation's processes must take this into consideration, and further, it must react within 1 calendar month of receipt of the request. This right is closely linked to the controller's obligations under the accuracy principle of the GDPR. As a matter of professional courtesy, the organisation should, if possible, restrict the processing of the data in question whilst it is verifying its accuracy. If the decision is taken to reject the request, the individual must be informed without undue delay about the organisation's reasons for not acting as desired, their right to make the complaint to the data protection authority in charge, and their ability to seek to enforce this right through a judicial remedy. This communication should be documented to allow the organisation to defend itself against claims of non-compliance. Obviously, as this requires some further processing of personal data, the individual should be adequately informed in regard to that. If, however, the decision is taken to follow the individual's request, and if the organisation had previously disclosed any relevant personal data to third parties, it has to contact them and inform them of the rectification. In case this proves impossible or involves disproportionate effort, this should be well documented to ensure the organisation's ability to defend itself at any later point in time.